First and foremost, welcome everyone. Good morning. We're so glad that you're here with us, and we hope that you get a lot of valuable information from this morning's webinar. My name is Chelsea. I'm with the Cromeens law firm. We are a full-service construction law firm based out of Houston. We serve all of Texas, and we're so excited to spend time with you this morning. And sorry, I was just looking at something real quick. So a couple of really exciting things that we'd love to share with you. What you see on the screen right now is one of 3 gifts that we'll be raffling off today. If you're just joining us, go ahead and pop your name, company name, and email in the chat to be entered in a raffle. Oh, 1 second, guys. Let me make sure this is shared. There we go. This is the gift, one of 3 that we'll be raffling off today. So this is our grand prize. It includes a bunch of Balcones whiskey and bourbon swag that you see on the screen, including this large sign, a hat, a bar key, 2 full-size bottles, 2 mini bottles, and the barrel, as well as a signed copy of Karolynn's new book, Quit Getting Stiffed, 2 branded tumblers, 2 branded koozies. It's an awesome, awesome kit. You'll definitely want to enter. So like I said, be sure to pop your name, company name, email in the chat to be sure that you're entered. Our second prize will be what's included in the box, the branded tumblers, the signed copy of the book, koozies, 1 full-size bottle. And our third prize will just be a signed copy of Karolynn's book, but it is an incredible book, just launched. It's called Quit Getting Stiffed, a Texas Contractor's Guide to Collections and Lien Rights. And you won't want to miss having this book on your shelf. It will be integral to the success of your business. And actually now, for a limited time, celebrating National Construction Appreciation Week, you can purchase the ebook of Quit Getting Stiffed on Amazon for 99 cents. So it is an awesome deal. You don't want to miss it. We'll be letting you folks know who won these gifts in the raffle in our follow-up email after the webinar. So enter while you can, and we'll be sure to let you folks know right after we're done. If you've got any questions throughout the webinar, save them until the very, very end, at which point you can send them in the chat and I'll ask them, or you're more than welcome to unmute yourself and ask Karalynn yourself. And I do believe that that's all I have for you folks this morning. So I'm going to go ahead and pass it over to Matt from Blue Book to do a bit of an introduction, and then we'll give it to Karalynn and take it away.
Thank you, Chelsea. Hello, everyone. I'm Matt Daniel with the Blue Book Network, and it's great to see all of you on the webinar today. This webinar, hosted by the Cromeens firm, is part of a year-long series to provide members of the Blue Book Network with information to help you run a successful business. We're looking forward to Karolynn's presentation. Not only is she going to provide you a lot of great advice on mitigating risk and running your business more successfully, she's got a lot of experience and grew up in the industry. So I'm looking forward to hearing what she has to say today. And I'd like to go ahead and hand it off at this point to Karalynn. Thank you.
Thank you. Thank you all for so much for being here. And like he was just saying, my goal in my company and my day-to-day business is to help small businesses in the construction industry run a better business. And that's because I grew up in the small business in the construction industry. My first job was for my uncle at an irrigation company, and the stresses of running a small business are real. And I learned a lot of things in my 16 years of practicing exclusively construction law that can really help a small business. And one of those things is a consistent collection strategy. And that's what Quit Getting Stiffed is all about, and this webinar today. There is a lot of stuff crammed in this webinar today, so it's kind of going to be a high overview of some things. And what it really boils down to, especially in the state of Texas, is, and we're going to get into this, knowing your place and your project and setting up a consistent collection strategy that works for your company and meets the laws in the state of Texas, which is something we can do for you in a free consultation on a one-on-one basis to say, here's your deadlines, here's what you need to do. Also in the book, there's some great, there's some great that kind of shows, you know, when you need to take what action. based on the type of project and your place in the construction food chain. So with that, I think, Chelsea, if you can go to the first slide, we're going to dive into liens in general in the construction industry and why they're important. Okay, next slide, please. Thank you. So as you know, if you're in the construction industry runs on credit, meaning that you as a material supplier or subcontractor or whoever is working on the project, you are going to extend whoever you're working for credit by working and then waiting to get paid. So you're going to go provide labor, provide materials, work, and then wait to get paid. And so that is basically, even though it's not cash, it's just the same. It's the same as extending money as a loan. And so it's, you know, you are owed that. That is a debt, right? And so in the world of credit, there are two types of debt. That is unsecured and secured. Unsecured debt, for example, is like if you get a credit card at Home Depot and you go there and you buy a bunch of stuff and you don't pay the bill. They have to sue you in court and get a judgment and then try to collect that judgment against any assets that you have. That is an unsecured debt. A secured debt is like when you buy a house and you don't have enough cash to pay for it, so you go to the bank and you get a mortgage and you say, hey, mortgage company, I need some money to buy this house. And they say, okay, but we're going to take back a lien on the house, a mortgage or deed of trust that says basically, if you don't pay that mortgage, they're going to foreclose and sell the property to satisfy the amount that they're owed. And that's what we call a secured debt. And in the construction industry, that's what a lien does, is it takes the debt that you're owed for the labor and material you improve somebody else's property with and secures it with a lien. So a lien is a piece of paper filed in the real property records, just like a mortgage, that says, hey, I have an interest in this property. And, you know, to the extent I'm owed money for the how much I improve the property with my labor and material. The big difference between a lien in this context and a mortgage is a mortgage you sign voluntarily. So you go to closing, you sign off on the loan that you're going to pay them. You're agreeing to take on that debt. Normally in the construction industry, you're not working directly for the owner, and so you follow the notice steps, and so it's an involuntary lien. So they don't have a choice. But with such a great remedy as having a lien, there's a lot of steps, especially in the state of Texas, you have to follow to do that correctly, because filing an invalid lien could be more harmful than filing no lien at all. So at the end of the day, even if you don't file a lien, you have your unsecured claim or your unsecured debt against the person that hired you on a breach of contract, just like a credit card, like that example I gave. You can go to court and sue them and try to collect. So you have that regardless. You could increase the likelihood that you're going to be paid by having a security in security interest in the property with a lien. And so that's kind of what I'm going to go through today of the steps generally in Texas to have a valid lien. Okay, next slide, please, Chelsea. In Texas, there are two types of liens. When you're working directly for the owner, you have what's called a constitutional lien. And that means really you don't have to have any notices. You can just file your lien and it's enforceable. But that's when you're working directly with the owner. And as long as you file it before that owner sells it, your lien will be valid. So in that situation, when you're the general contractor working for the owner, you have what's constitutional lien, and then the notice provisions we're about to go over won't apply to you. For everybody else who is not in direct contract with the owner, you can still have lien rights, but there are rules that you need to follow and notices that need to be sent before you can do that. And that's called a statutory lien. And it's called that because it's laid out in the laws and the statutes. And so all the rules to have a valid lien are explained in the statute. So that's why it's called a statutory lien. A constitutional lien, as the name implies, is called for in the Texas Constitution, and it just exists in the Constitution. When you're not in direct contract with the owner, there's more rules that you have to follow. And of course, you know, the legislature made these rules, and that's found in the statute, which is why it's called statutory liens. So next slide. If you don't have a constitutional lien, the next step in filing a valid lien is knowing your place and knowing the type of project. And when I say place, can you go to the next slide, Chelsea? Thank you. This is what I'm talking about, knowing your place in the construction food chain. So what I've done is the book is based like this too. And if you work in other states, I've I have the rules for all 50 states at Subcontractor Institute for free. If you ever need to reference your lien rights in other states, that's all there. But I've broken it down because into place 1, place 2, and place 3, because general contractor, original contractor, those terms are kind of used interchangeably, but I want to be clear on our position in this construction food chain. So place 1, like I said, would have a constitutional lien. Place 2 and 3, and then even below, would have a statutory lien, which means there's going to be rules that you have to follow. And the further down you are on the construction food chain, the faster you're going to have to do something to preserve your lien rights, which we're going to get into here in a minute. But I think it's important to have an overview of, you know, lien rights exist to make sure you get paid, but at the end of the day, there's going to be a notice system, because the whole purpose of the law, you can have a lien, but we don't want to have an owner or general contractor have to pay twice if we can help it. And so the whole notice structure we're going to get into is to prevent that from happening. So just know that up front. So next one, first action. Okay, like I said, so the first action is based on your place. We're going to just walk through for an example. If you are a place 3 subcontractor or material supplier on a commercial project, and we're going to go over the types of projects, but let's just say a shopping center, for example, build a building from the ground up is a commercial project. The first notice you're going to have to send as a material supplier or subcontractor in place 3 or sub is the 15th day of the 3rd month. 15th day of the 2nd month, sorry. So if you're working in September, and it doesn't matter when in September, whether it's the 1st or the 30th, the notice rule is still the same. You'd have to send notice September, October, November 15th. And that first notice just goes to the place 1 contractor and says, hey, I'm down here, I'm lower on the food chain, I haven't been paid. Here's what I'm owed money for. So, but on that same project, if you're in the place 2, your first action is not till the 15th day of the 3rd month. So September, October, November, December 15th, your notice goes out to the general contractor and to the owner saying, hey, I haven't been paid, I'm owed money. So what place you're in, what place you are in is when you'll have to take the first action. So, and the next thing that also describes what actions you're going to have to take to have a valid lien. Can you go to the next slide, Chelsea? Is the project type. So these are the different project types in Texas. On homesteads and residential have shorter timelines than the other types because they usually move faster and because homesteads are protected at all costs in Texas. So we have a homestead, which this is a property that somebody is living in on a full-time basis. And a married couple can only have one homestead. And if you work on homesteaded projects, call me, let's have a discussion, because there's a whole bunch of steps that need to be followed to properly have a lien on a homestead that are not addressed in depth here. It's addressed in depth in the book as well, Quick Getting Stiffed. And residential has a short timeline as well, but when I'm saying residential, it is a single family home all the way up to a quadruplex, but the important part is that it's owned by an individual. If a property is owned by a company of any sort, then it's not residential, it would be considered commercial. So anything that doesn't follow into the ones above or the ones below is considered a commercial project. And so those are the types of private projects in Texas. And then you have Texas Public Works, which are libraries, fire stations, things like that, that the state is having built. That is going to be bonded job, which we'll get into in a minute. And then the federal projects, which are like airports, army bases, and all of these things have different timelines and different requirements. So you got 2 components: is where is your place, what is your project type, and then we can talk about what is the first step you need to take and when is the timeliness of filing a lien and having a timely notice and a valid lien. Can you go to the next one? Okay, and so obviously you realize that there's a bunch of liens, a bunch of laws to have a valid lien. And so if you can get to the position of a constitutional lien claimant, that'd obviously be preferred because you wouldn't have to follow all those notice requirements. And so there's this thing in the law called a sham contract. And what does that mean? That says although a different company owns the property and a different company is the place 1 contractor, if they are owned and operated by the same people, you can collapse basically the place one and the owner will become the place one, but will become the owner altogether. So you're collapsing that place one into just the owner, and the people who contract with the one contractor would actually have a constitutional lien. So this can save projects sometimes, because you don't know until we do the research if the companies are controlled by the same person. If you think you're out of timelines and you know there's something that telling you that they could be related, it's worth having somebody look into it, because even if you're out of your timelines to have a statutory lien, you could have a constitutional lien if they're controlled by the same people. So it's always worth looking into, either at the front of the project or at the end of it if you think you're too late. So important thing to note there. These are the technical requirements for what needs to be in a lien that is filed. So I put this up here so that you know if a lien has to be filed, this is the information that we're going to need. So the sooner you can get this information, obviously, the better. And the thing about having a consistent collection strategy is to get as much information as you can up front, and hopefully you'll never need it. But if you have it, then it's really easy to follow the steps and you're not scrambling trying to get this. Because the main thing is, the amount that you're owed, the full amount that you're owed. So you need to keep good records on that, the name and address of the owner. The big thing here that also takes time is the legal description for the property. Now you can find that on like appraisal district records. Sometimes it's not that easy to find, but just knowing these things up front are what you'll need will save you time in the long run if you have them on the front end. Okay, next slide. All right, steps for having a valid lien. Now, go to the next slide, please, Chelsea. In every state, there are notice requirements. And basically what the notice requirements are is that you're sending it to somebody up the food chain to let them know that you haven't been paid. So they have the opportunity to withhold payment from either the place one or place two contractor to make sure that you get paid. And having studied all 50 states, they all have lien rights and they all have different timelines. But the one thing I can tell you is that there's no penalty for sending notice early or sending more notice than what's required. And so I tell you that to say that sending notice is a very effective tool to getting paid, especially if you know that there's an issue or you think that there's an issue. Just send a notice to the owner of the general contractor saying, hey, I'm not being paid. And if the person who's not paying you really hasn't been paid, it is very likely that you'll shake the money loose, so it'll come further down the food chain. So like I'm saying, we're going to go over these timelines. There's nothing wrong with sending notice early and often. So one of the big things in Texas that is a huge misconception out there is that the lien timelines start from the last time that you're owed, the last time that you worked, that you're owed money for. That is completely wrong. It starts from the first time. So if you're working in September, October, and November, your lien timelines start from September. And here's the other thing is that if you're working on a project for, that timeline, as long as you're sending timely notices, you can wait until you're done to file your lien. You don't have to file a lien for every month that you're owed, as long as you're sending notices. But so the main thing is that if you're working in September and you're not paid in September, that's your timeline. So like I said, if you're place 3 and below, November 15th is your first notice, and then you have to send another one on December 15th. If you are place 2, then your first notice is the 15th day of the third month. And then the timing of the filing of the lien, I think we'll get into here shortly, but it all has to do with the type of project. So know that. So do the researches. If you're going to send your notices, which you can set up, I have all my clients set up to do as much of the process as they can. So you just do that. What I do is before you start a project, before you sign the contract, or before you ship out the material, you need to know the project name, the project address, the GC name, the GC address and phone number. If you send out any notices on your own, make sure that the address is correct. It doesn't count if you send it out to the wrong address. Currently in Texas, I'm hoping this will be changed soon, and in most other states, the only way to be 100% sure and prove when your notice is sent out is to take it to the post office and have them stamp the little portion of the green card, because that is the only way you can conclusively prove when the letter was sent out. And that's important because I know a lot of lien filing services just do it through the post office. And here's what happens. Okay, we file the lien, you get a letter from the owner saying, yeah, I don't owe you this money and you're untimely. And I go trying to prove that you're timely. And you don't be wrong, you put it in the post and somebody sent it out, said they sent it out on the 15th, but we don't have it stamped. And then the only way I can track it is when it enters the post office electronic system, which you can bet is not normally the day it actually goes out in the mail. It's a few days later. And in Texas, when I say the 15th day, it is the 15th day, not the 16th, not the 17th. It has got to be that day or you miss the whole month. So that is essential, taking it to the post line and having it stamped. And each month has to meet its own notice requirements. So like I was saying, for September, you need to send notice in November. For October, you need to send notice in December of the amount that you're owed. Like I said, you can send it early, you just can't send it late. Like I said, it's a notice early and often. And so let's go dive into how to file valid lien on commercial projects. So if you are a place 2 contractor, the first notice you need to send basically is an intent to lien, and it goes to the owner and the place 1 contractor that says, hey, I haven't been paid. Like if I'm working in September and I haven't been paid by December, I'm sending a notice to the owner and general contractor saying I haven't been paid. If you don't pay me, I'm going to file a lien. Okay. If you're a place 3 contractor, which means you're below that, your notice, like I said, is the 15th day of the second month. It needs to go to the general contractor and says, I'm here, I'm supplying materials, or I'm providing labor, I haven't been paid. And then as the place 3, the next month, the 15th day of the third month, you send the same notice that the place 2 contractor does. So it goes to the owner and the general says, hey, I'm here, I still haven't been paid. You need to pay me or I'm going to file a lien. So that's the timeline. And then the lien has to be filed on a commercial project the 15th day of the 4th month after last work, or 30 days before final completion. So if you're working September, October, November, and you last work in November, then you got December, January, February, your lien has got to be filed by March 15th or within 30 days of final completion if the project is finished before March 15th. So you have the 15th day of the 4th month timeline, but that could be cut off if the project's complete, and that's due to retainage, and we'll get into that in here in a second. But just know up front that all lien requirements are different for all 50 states, and be leery of an online lien service that has the same process for all states. Because there are some states that require like what we call a pre-lien notice that needs to be sent like within the first 15 or 20 days of working on a project. I know California is that way, Florida's that way. There's a couple other, but those are the 2 I can remember off the top of my head. And liens are such a tricky thing and a tricky thing to get done right. You know, I would really go to an attorney or firm. You know, I'm biased that we're the best at it because I think that we are, but there are other firms out there that just get to know one, because it's really hard to find one that, because it's a specialty at the last minute. So that's a worthwhile time investment to do that on the front end. Okay, I also wanted to take a little bit of time today to dive into what is retainage. We all know that retainage is taken out of our pay apps, and we all know that it's there, but do we really understand what retainage is and why it's there? Retainage is not required in all 50 states, but it is required in Texas. And so the legal definition of retainage, it's 10% of the contract between the owner and the place 1, the general contractor. Okay, so I know it comes down in the pay apps through subs and everything, and you get retainage taken out of your pay application, and that's fine. It just legally, that's not the definition of retainage. So retainage is 10% of the prime contract, basically. And what the owner is required to do is to withhold that 10% until 30 days after final completion, right? Which is why you need to have your liens filed within 30 days of final completion, because that's basically the owner's liability is limited to that 10% if he properly retains it, okay? So meaning that on $1 million project, the owner can limit his liability to lien claimants to $100,000 if he properly withholds that $100,000. That's why retainage is so important, and why owners, even if it is required by law, but why they should withhold retainage. Next slide. And why you should. So retainage, like I said, technically the owner is supposed to pay the place one contractor 30 days after final completion, and they shouldn't hold that money for that time period. And then after that, they're free. If you don't file a lien, they're free to release those funds to the owner. So, which brings up the next slide. In my experience in the construction industry, I tell my clients to build in the price of filing a lien for your retainage, because it is very common to get to the end of the project and all you're doing is retainage, and then you're waiting 6, 9, 12 months to get paid your retainage. And here's why, is that if you don't have a lien filed, the owners most likely already funded the GC. The GC doesn't need you out there on the project, so you have no leverage. If you file a lien just for retainage, even when you're complete or when the project's close to completion, the general contractor will either have to pay you before they get paid, or the owner will have to joint check you on the retainage. And here's why, guys. Next slide, please. Is that retainage is 10% of your contract amount. Are you making more than 10% on a project? If not, that's your profit. Why would you not secure it? And time value of money, how much is that money worth when you get it 9 months later, as opposed to, it's already bad enough if you're one of the first guys on the project, you're not getting retainage till 30 days after that project's done. That's, could be a very long time. But then to get it 9 months after that, that money's not nearly worth as much as if you can get it faster. And it's leverage. It's a tool to make sure you get paid. And I build in the cost of filing a lien on retainage on a project. I think it's a good business strategy. Okay, so like I said before, retainage can limit the owner's liability to that 10%. So back to the example of $1 million project, the owner's liability can be limited to $100,000. And why does that matter to you as a lien claimant? Okay, so as you as a lien claimant, if the general contractor or somebody runs away with the money and there happens to be $300,000 with the lien claimants and only $100,000 in retainage, now you all got to share that, and you get to share it based on who's owed the most money. You can increase the owner's liability by trapping funds in their hands. And what does that mean? That means if you send a notice that says, and we'll get to the exact language in the next slide. If you send a notice that says, here it is this is the exact language, 1, 2, and 3 here. If you put in your notice letters, that will put that now if the owner pays the general contractor, the place one contractor, after they receive this trapping notice and didn't make sure that you were paid, now they're liable for that fund too. So you can increase the amount of the owner's liability beyond retainage if you give them this trapping language and they pay anyways, right? And technically how the trapping is supposed to work, it doesn't always work this way in courts from my experience, is that if the GC doesn't dispute your claim and your trapping language is in your notice letter, the owner shall pay the claim within 30 days. So, I mean, that's some great leverage. So if you're sending any notice to the owner, include this trapping language, because you never know at the end of the day when you're going to end up in a big case fighting over retainage. It happens I have one now. And what usually happens is the owner will sue all the lien claimants and say, hey guys, this was $1 million project. I know you have $300,000 in lien claims. All I have is $100,000. Here it is, you guys divide it up. And so they'll bring a lawsuit to have that done, basically having a judgment say, yeah, that's your only liability, which if you have sent one of these letters with the trap fund language, you could increase that. So just something to keep in mind. All right, bond claims. All right, so the government protects themselves at all costs. And so you can't file a lien on a public project, whether it's federal or state. There's no lien rights on public projects. But the place one contractor on all public projects, well, I say that, on public projects, I think it's over $50,000 in Texas, and it's varying amounts throughout the 50 states, are required to get what's called a payment bond. They are required to get normally to a performance bond, but that's for the governmental entity to file on in case the GC can't finish the job. But a payment bond makes sure that everybody who's extending credit to that GC for that project would get paid. So just like a lien. The thing that's tricky about liens is that the bond isn't generally filed anywhere. And so to get it is a little bit precarious. And so the better idea is to get it before, when the contract's signed, before there's any credit issues, because getting it afterwards is nearly impossible. So if you'll go to the next slide. Like I said, you can't have a lien, bond claims, get the bond up front. On federal projects, and in the book I mentioned, there's a website where you can go to request it. In Texas, what you have to do if you don't have the bond and you need to file a bond claim, and the notices are the 15th day, the notice structure is the same for a lien, it's just you're sending it to the bond company instead. You have to send a 10-day request to the general contractor to give you the bond if you don't have it already. The problem with that is that their only penalty for not giving it to you is the cost that it will take you to get it, which doesn't make any sense to me, because you can not have a bond claim, basically not secure the amount that you're owed if they don't give you that bond. Or you can do a public information request to the entity that's having the work done, but that takes a minimum of 30 days. Well, they have 30 days to respond. Sometimes it's faster, sometimes it's not. So the other thing to know, if you're going from like private work to federal work, is public work pays a lot slower just across the board. You're talking about government entities that don't normally move as fast as private projects. So just know that if you're going to go up front, there's two things to consider: get a copy of the bond on the front end, and have cash in the bank to be handled if you'd have to cash flow the whole project before you actually get paid. It just depends. And the other thing that's interesting about federal bonds is if you are at place 4, you do not have bond claim rights. So just know that going into it. Only place 3 and above does. Like, you can't file lien on federal projects or any state projects. Place 2 and 3, suppliers can file federal bond claims. Get a copy of the bond before you start working, hugely important. Or you can get it from the federal government. And on the federal project, technically you only have to send the notice to the GC. I would still send it to the bond company. It's going to be way more effective. And then you have 1 year from last work to enforce your bond claim by a suit. So those are the highlights of bond claims. Okay, another thing that I wanted to address in this webinar that I think is hugely important is lien waivers. If you need a copy, in Texas we are lucky. Lien waivers are statutory, meaning they have created them. There's a certain form. Here's what we're going to use, and here's the process of how they work, right? Conditional lien waiver upon progress payment. So that's the first one, right? If your project, you're submitting pay apps on a monthly basis, you submit for that. So like if your first work is in September, you're submitting your pay app for September, you're going to submit a conditional lien waiver that says, hey, I'm owed $10,000 for September. Once you pay me that $10,000, I'll be paid everything but retainage, right? And so you submit that with your September pay app, you get paid, the check clears the bank. When you issue your October pay app, you do an unconditional pay app for unconditional lien waiver for a progress payment for September work, and a conditional for October. And that's how it goes throughout the project. And then on the final payment one is when you're billing everything, including retainage. So when you bill everything, your last pay app, that's when you'll issue a conditional upon final payment, and you don't sign an unconditional upon final till you've actually been paid everything, including retainage. And so, like I said, if you need, go to the next slide, Chelsea, please. If you need any of these forms, you can find them at Subcontractor Institute. They're there for free. But here's the thing that I want to warn you about, and is that an unconditional lien waiver has this exact language at the top and states that you have been paid. If you sign an unconditional lien waiver and you haven't been paid, you're pretty much screwed. So, and here's what I tell my clients, because I get this all the time. They're always asking you to sign unconditional lien waivers. If you know this person that you're working for and it hasn't been a problem, you're probably fine. I would not do it for somebody that I'm working with for the first time. Because you come to me, I send out an intent to lien letter, I get this back like, oh, they signed an unconditional lien waiver. I'm like, oh, okay, well, there's not a whole lot I can do there. As far as lien rights go, you still have your breach of contract right against whoever hired you, but actually you're releasing that too. So you're releasing everything for this work. So don't sign these unless you've actually been paid. Or like I said, if you've been working with somebody for a while and that's how they work, then I think you're right. Then you think you're fine. It just know the risk of signing an unconditional lien waiver if you haven't been paid. The next thing, just lien waiver versus releases. The lien waivers are what we just went through, what you're signing as the project goes on. An actual lien release is only required if you have filed a lien. And then we need a release to remove that lien from the real property records. And when I say release, here's what happens. If you file a lien, it's going to show up in the real property records forever, but you can show that there's been a release and it's not effective anymore. And so a release is something that has to be notarized and have a legal description and reference the lien that is filed. And I know there's been some discussion about how effective is a lien waiver if it's not notarized, especially with the pandemic and everybody not having it. And the main thing for a notary on a lien waiver is to prove identity. Like, you know, did this person really sign this? And so I've been telling my clients, especially during the pandemic, if you can't get to a notary, you know, having an email from somebody saying, hey, here's the signed lien waiver, it's me, I signed it, that's evidence enough to say, hey, this is my signed lien waiver. So just know that it doesn't always have to be notarized depending on the situation, just some evidence of who's actually signing it and it being verified. Something that has to be filed in the real property records most definitely has to be notarized because it has to be notarized to be filed. And there's been some online notaries that have been very successful too. So key points, don't sign an unconditional lien waiver unless you've been paid. Lien releases are the ones that are filed with the county clerk. If you get paid for a lien that you have actually filed, you have 10 days to give the other side a release. So just know that going into it. Okay. So at the end of the day, what's most important, I mean, knowing your lien rights is obviously important, but having a consistent collection strategy that works to make sure that you have the cash flow that you need to run your business, but at the same time preserving your lien rights. So, you know, some of the things that we kind of went over in this is important. Can you go to the next slide? For collections, that you work on the front end. Have a copy of the signed contract for your records before you start working. If you're signing somebody else's contract, I would really have somebody review it, and not from the fact that you need to negotiate everything, but just from the fact that you need to understand everything. And subcontracts are very unfair and one-sided. There's actually another book that I wrote on that called Quit Getting Screwed. If you haven't read it, very helpful. Or my firm also will decipher your contract for you for a flat fee, starting at 15 page, from 0 to 15 pages is $550, and we have like a 2-day turnaround. So if you need somebody, and the main thing there is like, I'm going to tell you where the risks are, I'm going to tell you what this says and what you're agreeing to do, because those things are horrible to read. I don't know if you read any of them, they're pretty bad. Knowing the owner and the correct project address before you start, if you're, you know, if you potentially have lien rights, hugely important. Knowing when you have to take action and how to do that. And a lot of it you can do on your own. You don't have to have an attorney. Like sending that first notice letter, you can do that. Just make sure that you're doing it on a timely basis and how to do it. Correct address and phone number for the general contractor. You know, the thing about my firm too that I found is very effective is that we don't just send notices. So like if you hire me on a lien or as part of your collection team, the first thing we do before we send out any notices, we make phone calls. We're going to find out, hey, will they answer the phone? Will they tell me what's going on? Is payment coming? Is just something holding it up? It's very effective. And I'm not calling and screaming at people. I'm just saying, hey, you know, we haven't been paid. Here's where we're at. Here's what's going to happen. Just let me know what's going on. So I think that is another huge part that a lot of collection places and online lien filing places miss out on is the phone call. And here's the thing is that if I know my timelines and you're answering the phone and you're dealing with me, a lot less likely to have to file a lien. I mean, like most, like 80 to 95% of the people that come in to hire me for a lien never actually end up filing the lien because we get it paid before the lien is filed. And that's because we make phone calls and we know our timeline. So yes, you can promise me a payment, but I'm not going to let you, I will wait as I promised, but I'm not going to let you push me outside my timelines. I'm still going to file a valid lien at the end of the day. So that's the thing is that if you know what your timelines are, you can say, hey, yes, I agree that, you're going to pay me in 2 weeks. That's great. But here I have to send this notice on this day just to preserve my lien rights. Because I've had a bunch of clients come to me and they were promised payment. And I think purely from the standpoint to push somebody outside of their lien rights, because after the lien rights expired, they quit answering the phone and they really didn't get paid. And they came to me and there's like, you missed the timelines, there's not a whole lot I can do. So knowing that is hugely important on the front end. A separate collection department, then a sales department, accurate records. This is a huge thing too. At the end of every month, or right, what I normally do is today's the 15th, so that's the lien timeline in Texas. So we start looking at our clients' open invoices starting on the 5th all the way through the 10th to say, hey, these are the ones we're going to have to push on. These are the ones that are going to have to need notices, GC notices, or intents, depending on your place and your project, but look at it on a consistent basis. I don't know how many people come to me for the first time and they have, their list of open invoices and the bottom line is like over $300,000 and a lot of that money is over 60, 90 days and they don't know what to do and it sneaks up on you. If you're not watching the numbers, they will run over you. So let's look at them. And don't be afraid of them. Here's what they are. Here's the plan. Here's our plan of attack. We're going to send GC statements on this. We're going to make phone calls. We're going to do this and dive in and really get it done. And I will tell you from experience, you don't have to scream loud. You don't have to threaten. You just have to have a consistent, quiet voice saying, hey, here's what's going to happen if I'm not paid. Here's what's going to happen if I'm not paid. And you being that squeaky wheel will get paid. You're going to get paid over the guys that don't have that squeaky wheel consistent collection strategy. And so that's what I'm trying to set up here. Regardless of your place or project, you can set it up where this is what we do every time. This is what we do every time. And when that happens, it just becomes part of the process, and then they make sure that you get paid because they know what happens if you're not paid. So, which brings me to my conclusion, which is, guys, all of these things are, like I said, the pain that I see in companies and small businesses, Wednesday afternoon, Thursday morning, getting very nervous about trying to make payroll because that check didn't come in, that money that I'm owed. How am I going to make this work? How am I going to do this? And if I'm telling you guys, if you'll spend some time having a consistent strategy in place, then that'll be less of a worry because your cash flow will be more under control. Worrying about how you're going to make payroll on Thursday will really be a thing of the past, just because you're going to be in control and you're going to be in that consistent, okay, I haven't been paid. This is what I'm going to do. Yes, I believe that you're going to pay me, but I got to protect myself and I got to protect my family. And this is the way I'm going to do that. So like I said, we're here to help you do that. We can put in a collection strategy. I have flat fee liens. I have subscription pricing, which is, unlimited on a monthly basis. So there's lots of affordable options to help you guys do this. So, all right, and then I will open it up for any questions. You can either unmute yourself or put it in the chat and Chelsea will ask me, whatever's easiest.
You've already got one here in the chat. It says, oh, this is regarding getting some of the information. They arrived a little bit late, so don't worry. We'll be sending out a follow-up email with a copy of the presentation so you can get all the information that you missed after the fact. If you guys have any questions for Karalynn, you're more than welcome to unmute yourself and ask her. Send them in the chat and I can ask.
Like I said, I know that was a lot of information. But the book goes through it too, kind of like I explain it. Go to Amazon, order the book.
And a reminder, it's only 99 cents for National Construction Appreciation Week, so you got the whole week to grab it as well. And if you don't have any questions now, but you think of some later, we'll also be sending out Karolynn's contact information in the follow-up email. So you can reach out to her and ask those questions then as well. We've got one in the chat here. It says, do the same rules apply to design professionals when they are hired by the GC for design build projects?
Correct, yes. You would have constitutional lien rights. How much is a subscription to the law? Okay, so for people that just have liens and not bond claims, it's $1,000 per month plus actual cost. If you have bond claims and liens, it's $2,500 a month. The book
The
is
name of the book? Oh, go ahead.
Quit Getting Stiffed. I'm sorry, I'm reading in the chat too. What if you don't get paid on change orders? Okay, it would go from the same time frame of when you did the work. When you did the work is going to kick off your time. So if you did the change order work in September, same thing. If you're placed to September, October, November 15th, and then on the 15th day of the third month. So it just matters when you did the work. Okay. And the other thing though is make sure we have signed change orders.
If you are past 90 days, is there anything you can do or just hope they will pay?
It depends. You could still have a lien for retainage if the project's not complete. So retainage, because it technically doesn't become due until the project's complete, you still have time to file your lien on retainage. And you might want to look and have us look at it just to see if it's a sham contract, which would give you a constitutional lien. And here's the other thing is that even if you don't at the end of the day end up filing a lien because we know it's not correct, right? You can still send an intent to lien that says, hey, if I'm not paid, I'm going to file a lien and make some phone calls and go through that whole process. Just at the end, there's nothing wrong with doing that. It just don't file the actual lien.
What's your cost to file a lien for me?
So for a singular lien, it's $1,070. Like I said, on the subscriptions, it's $1,000 a month for unlimited liens. And then we do liens in other states too, so it depends on the state that you're in. But that's for Texas.
Awesome. Does anybody have any more questions for Karalynn? Alrighty, it looks like we've got nothing else coming in. So with that, we thank you guys for joining us today. Like I said, we'll be following up with the results for the raffle winners and Karolynn's contact information in case you've got any other questions, as well as copies, both video and the presentation itself for those who missed or those who would like to recap.
Gotcha. I see one other question in here.
I see it.
Did a job for the GC, they finally got paid 100%. They did not pay me. Is the lien valid against the owner if they paid the GC? Yes, the lien would be valid. The problem is are we timely? And here's the thing, is that a pay when paid clause does not stop you from filing a valid lien, right? Actually, following the lien process is kind of a way to get around the pay when paid clause by forcing the owner to pay the general. You can still definitely have a lien. I just have to look at the timelines, the time of it, based on your position and how long ago the work was done. So, but like I said, all those subcontracts that have pay when paid clauses, you can still send out your lien notices. There's nothing stopping you from doing that. And in the state of Texas, any contract that tries to pre-waive your lien rights is not enforceable. So those contracts that say, hey, I hereby waive my lien rights, at the end of the day, that's not going to be enforceable. And that's the same in most states.
All righty. Thanks for joining us, everyone. Hope you have a great day, and we'll be following up with you soon.